The high courts have quashed the FIRs and the subsequent criminal proceedings on an erroneous interpretation of SBI versus Rajesh Agarwal, 2023, 6 SEC 1. While the borrowers argue that the actions of banks in classifying borrower accounts as fraud according to the procedure laid down under the Master Directions on Frauds is in violation of the principles of natural justice, RBI and lender banks argue that these principles cannot be applied at the stage of reporting a criminal offense to investigating agencies. At the outset, we clarify that principles of natural justice are not applicable at the stage of reporting a criminal offense, which is a consistent position of law adopted by this court. In Union of India v. W.N. Chadda, a two-judge bench of this court held that providing an opportunity of hearing to the accused in every criminal case before taking any action against them would frustrate the proceedings, obstruct the taking of prompt action as law demands, defeat the ends of justice, and make the provisions of law relating to the investigation lifeless, absurd, and self-defeating. Again, a two-judge bench of this court in Anju Chaudhary v. State of UP has reiterated that the Code of Criminal Procedure 1973 does not provide for right of hearing before the registration of an FIR. Chapter 8 of the Master Directions on Fraud provides detailed procedures to be followed by the banks before forming an opinion to proceed with a criminal complaint against the borrowers. Under the said chapter, the lender banks have to report a borrower to the CBI after classifying the borrower's account as fraudulent. However, the classification of the borrower's account does not simpliciter lead to reporting of criminal complaint with the enforcement authorities. It also entails penal consequences for the borrowers as laid down under Clause 8.12. The process of forming an informed opinion under the Master Directions on Frauds is administrative in nature. This has also been acceded to by RBI and lender banks in their written submissions. It is now a settled principle of law that the rule of audi alteram partem applies to administrative actions apart from judicial and quasi-judicial functions. It is also a settled position in administrative law that it is mandatory to provide for an opportunity of being heard when an administrative action results in civil consequences to a person or entity. The conclusions are summarized below. 1. No opportunity of being heard is required before an FIR is lodged and registered. 2. Classification of an account as fraud not only results in reporting the crime to the investigating agencies, but also has other penal and civil consequences against the borrowers. 3. Debarring the borrowers from accessing institutional finance under Clause 8.1 to .1 of the Master Directions on Frauds results in serious civil consequences for the borrower. 4. Such a debarment under Clause 8.1 to .1 of the Master Directions on Frauds is akin to blacklisting the borrowers for being untrustworthy and unworthy of credit by banks. This court has consistently held that an opportunity of hearing ought to be provided before a person is blacklisted. 5. The application of audi alteram partem cannot be impliedly excluded under the Master Directions on Frauds. In view of the time frame contemplated under the Master Directions on Frauds as well as the nature of the procedure adopted, it is reasonably practicable for the lender banks to provide an opportunity of a hearing to the borrowers before classifying their account as fraud. 6. The principles of natural justice demand that the borrowers must be served a notice, given an opportunity to explain the conclusions of the forensic audit report, and be allowed to represent by the bank's JLF before their account is classified as fraud under the Master Directions on Frauds. In addition, the decision classifying the borrower's account as fraudulent must be made by a reasoned order. 7. Since the Master Directions on Frauds do not expressly provide an opportunity of hearing to the borrowers before classifying their account as fraud, audi alteram partem has to be read into the provisions of the directions to save them from the vice of arbitrariness. From a perusal of the above paragraphs, it is clear that the principles of natural justice are not applicable at the stage of reporting a criminal offense. It has further been clarified that providing an opportunity of being heard prior to the commencement of a criminal action, i.e. registration of an FIR, would frustrate the very purpose of initiating a criminal proceeding, which is to meet the ends of justice. More specifically, Para 98.1 of Rajesh Agarwal's case explicitly states that no opportunity of being heard is required before an FIR is lodged or registered.